Welcome back. You're watching The Money Show on ET. Now we had an in-depth discussion on investing, lessons to learn from HNIs, and of course what to not ape as well. Let's move forward now and talk about another very interesting topic, and that's with respect to the new Draft Model Tenancy Act. This is something that's of course still draft. It's still in the works, so we are still to see the final print, but it's been released, and we have some of the details, so we thought it would be great to sort of peruse through these details, understand what the possible implications could be for tenants, for landlords, so they can better prepare themselves as well for the same. Joining me on the show is Kunal Arora, joint partner with Lakshmikumaran and Sridharan Attorneys. Kunal, thank you so much for joining us today on ET Now. So to start with, I think this Draft Tenancy Act is something that we are seeing in the real estate space, impacting your residential landlords and residential tenants. We're seeing a change, in the structure after a very long time. Firstly, tell us, is this applicable to what kind rather of properties is this applicable to? Commercial, residential, your Pagri system as well. Which ones would this act be applicable to?
So this act would be applicable to residential as also commercial properties. Only a very specific kinds of properties owned by charitable trusts, government and the Waqf boards, sort of the properties are excluded. But otherwise, it is intended to cover both residential as also commercial properties.
Okay, all right. So it's applicable for residential and commercial properties. Now, Kunal, let's understand your reading of this act. What really pops out that could impact, a landlord and a tenant?
So I think the act is pretty balanced, I would say, from a landlord as also from a tenant's perspective. What it seeks to do is probably lay down the framework for the contract or the arrangement between the landlord and the tenant. And it tends to create a balance, and also tries to address some of the specific concerns which, based on past experience, have been observed to be impediments or, I would say, points of contention between the two sides. It does try to lay out a guideline or lay out a roadmap vis-a-vis such aspects for the landlords and the tenants to follow. Also providing for a reasonable government intervention, and also a dedicated dispute resolution mechanism to ensure that the litigations resulting out of or stemming out of the landlord-tenant relationships do not reach a level where they've been historically, and it's been probably brought into it's been introduced to kind of lessen the burden on the judiciary as a consequence of the disputes arising between the landlords and the tenants.
Okay. There's also a very interesting topic on the establishment of a rent authority, and furthermore, rent courts, rent tribunals. What will be the role of these three authorities? Would they also in some way be involved in the fixing of the rent, or am I remiss over there?
No, so the rent authority does have the ability to fix the rent in case there is a dispute, or in case they are unable to kind of fix the appreciation in the rent. But as I said, the entire framework has been introduced with a view to provide a dedicated dispute resolution mechanism for disputes between landlords and tenants, with the first port of call being the rent authority, and after that the rent control and rent tribunal come into being. And another interesting aspect which has been introduced in the Act is a strict timeline, at least as per the Draft Model Tenancy Act, that there is a strict timeline of 60 days for the rent control and rent tribunal to adjudicate the disputes which are brought before them. So this, if implemented well, it can really fast track the dispute resolutions between, in case of disputes between landlords and tenants. And that will have a long-term effect on the courts and on the entire judicial process vis-a-vis such matters.
What are the other, possible points of contentions between a tenant and a landlord that would be addressed by this rent authority? Do we know the entire jurisdiction yet?
See, that the rent authority has jurisdiction to try any matters arising out of the contract. If you see, the Act itself provides for many aspects, ranging from eviction to rent fixation to deposition of rent to termination to security deposit. It practically, as an Act, it delves into almost all the important aspects that can be otherwise taken care of through a detailed contract. And it does while it does not preclude the parties to enter into an agreement at variance from the provisions of the Act, but it does lay out a, like I said, a roadmap for the parties to follow vis-a-vis all those aspects which form the core of a lease agreement. And therefore, to say that rent authority jurisdiction would be limited to some of those aspects would be incorrect. It would be practically the rent authority, if the implementation mechanism is laid out well, will have the ability to try any and all disputes arising between the landlord and the tenant vis-a-vis the tenancy agreements.
Okay, all right. You know, another very interesting point, which I think so far has as well been a point of contention in some cases, is the rights and obligations of the successor, more importantly of the tenant. What was the most common practice currently, and what does the new Draft Model Act have for the successors of the person in whose name the tenancy was established in the agreement?
So there are two parts to the question. First, I will answer about the successors. The Act does provide that in case the landlord or the tenant is no longer there, the successors will have the same rights and obligations which the tenant or the landlord would have had under the original agreement. And to that extent, it does confer the rights as also the obligations on the heirs of the respective parties. The second part of your question dealt with what are the obligations of the tenant. Historically, we've seen that the rent control acts or the tenancy acts of various states were termed to be, or at least considered to be, tenant friendly. But what this act does is it actually lays down responsibilities for both sides, the landlord as also the tenant, in terms of how they will operate and what is the extent of their rights and obligations. It actually, interestingly, even goes down to the last detail of specifying what are the kind of repairs that a tenant is required to undertake, as opposed to the repairs or the changes that fall within the lap of the landlord. And therefore, I think the kind of detailing that we see in this Tenancy Act shows an intent of the legislature to really reduce the burden on the judiciary owing to such disputes between the landlords and the tenants.
All right, okay. So I hope this entire conversation has given a brief idea of what to expect once the new model, the tenancy, draft, book has essentially turned into a proper, full-fledged implementable law. Kunal, thank you so much for joining us today on ET Now and On The Money Show. And, I hope we can catch up once, this has actually been converted into a full-fledged law.
Sure. It's been a pleasure. Thank you.
All right, well, we'll take a very short break right here on the show. Don't go anywhere else. We will be back with lots more on The Money Show.